There's a chance I'm talking to somebody right now who paid something for estate planning that was some time ago, and maybe you didn't pay. That it's most likely you didn't pay anything, but you told the lawyer you wanted it done. Lawyer said he'd do it. You left. Y'all exchanged a few letters, maybe even a second visit. As a matter of fact, there's a good chance there was a second visit, and then just attentions wandered and time passed, and so you're watching this video thinking, I need to get some estate planning done.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen, Attorney-CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of Life's Third Act. Today, we're going to talk about estate planning. We're going to talk about what are the top 10 things that go wrong notoriously in estate planning. I mean, there are certain things that, as a practitioner, we see all the time, and they're just notorious issues that seem to creep up despite the best efforts of client and attorney in some cases. So I thought that we would go through this one by one. Let me give you a heads up that there are certain things that we could talk about that I'm going to consciously exclude. Taxes, tax issues, minimizing tax liability is a huge deal for many people in estate planning. I know that. As a matter of fact, they think of estate planning purely as an exercise, almost purely as an exercise to minimize taxes. So it's not that I don't find that subject interesting. As a matter of fact, as a CPA, I do find it interesting. And I find it very relevant to the lives of some people. But you need to know that as a fraction of the people that this is relevant to, it's pretty small. And here's the reason. You may not know, some of you do, that we currently have an exemption amount that's approximately $12 to $13 million. It's updated for inflation per person. So a married couple would have $24 million or so dollars that they would have exempt. Oh, this is my ever reliable best friend, Scout. She's a Belgian Malinois. You'll have to trust me on that. Anyway, so because of this exemption, it's so high that it excludes, I don't think it would be overstating it to say 99% of the people who need to do estate planning. So for that 1 or maybe 2% that it's relevant to, then I just want them to know on the front end that, yes, you need to consider those things, and we have done, and we will continue to do occasional shows dealing with the tax issues. But I recognize that so few of you care about the tax issues at this stage. Now, that may someday change. I mean, what's in place right now is due to expire at the 1st of 26. So maybe when or if that happens, if it's not renewed as it is now, and a lot of experts think it will be, but if it's not, and suddenly it's relevant to you, then yes, I'll be talking a lot about taxes. But for purposes of today's show, I'm going to focus on things other than taxes. So where do we start with this? So I've made this trustee list that I think is, I could have chosen to word some of these categories differently, but I think it captures the substance of what I would want to call your attention to as the top 10 mistakes commonly made in estate planning.
Strong roots are essential for a healthy tree, especially your family tree. That's why you work hard to take care of your family every day. At Tucker Allen, we know that taking care of your family means planning for the future. Our team provides personalized estate planning to help you protect your family, your legacy, and your future. From wills and trusts to long-term care and estate planning, count on Tucker Allen, personalized estate planning made simple.
Number 1, appropriately, is being candid with your attorney. This sounds like an obvious point, but I can tell you it's not obvious because people often want to think the best of their children. That's one motivation why they're not completely candid when they come in and sit down in, some oak paneled conference room of a lawyer. So there's that. But then there's this intimidating environment. They don't want the lawyer to think bad of their family. So there's that motivation. Sometimes there's just a lack of objectivity. There is a mother or a father who thinks that Timmy, who's now 33 years old and still living with them and drinking regularly, more than would be healthy, and yet they think that he's perfectly capable of managing his money, which he has none at this point, and as well as they think that he might be a good candidate for trustee. We'll come to that in a minute. So there are little things like that, not so much little, but multiple things. And some are little, some are big. But when you are doing estate planning, there's no better time to be just completely and utterly frank with your lawyer. Remember, your lawyer has seen it all. So besides, whatever your lawyer thinks, it's irrelevant. I mean, the point that's relevant is for him or her to have the information they need to help you plan. So you've got to go in prepared to say things to that person, your lawyer, that you wouldn't say perhaps to your friends, even to someone in your church, your synagogue. I mean, it's understandable that you don't share some things that you might regard as embarrassing or may reflect bad on you or your family. That's understandable. But it's not understandable when you're doing estate planning where it's really critical that you make projections about people. And these projections need to be the best possible. You may make mistakes just being completely frank and being very thoughtful and considerate about how to implement the right plan, incorporating, an accountant and especially your lawyer to help you design a plan that's compatible with all these factors that you need to deal with. But those things, those failures many of those can be overcome by proper planning. There'll always be uncertainty. We know that. But if you plan properly, many of these can be overcome. And you've just got to include your lawyer in the circle. So number one is when you go see your lawyer, be frank. Be completely frank about what you think and what you feel, and be subject or willing to be challenged. And that's the reason sometimes somebody in the room can be helpful to that. But often somebody in the room may actually be an obstacle to some of that frank conversation. So that's number 2 on my list. And these are not necessarily in order, but they're all crucial. Number 2 is controlling who is in the room. This is something that your lawyer will be very concerned about. If your lawyer seems to stop you and 3 or 4 family members that might be with you from coming into the conference room, if he decides to talk to you first there outside the conference room and ask a few questions about maybe who is essential or who is everyone that's gathered there, that is really a lawyer that's being on top of his or her game. They're aware of the rules of ethics. The rules of ethics require that we be very careful about who we disclose confidential information to in order for attorney-client privilege to be upheld. So attorney-client privilege is this marvelous thing for clients and lawyers, but especially for clients, because it says that whatever you say to your lawyer can never be repeated. Nobody can be forced to get on a stand and disclose that except you yourself. You control what would be that protection. So you can waive that protection, but nobody but you, the client, can do that. Now, it kind of makes sense that an exception to that where you can blow that confidentiality is when you bring somebody into a conversation with a lawyer that's not an essential person to that meeting. And while you'll see some language in cases being essential, really it's somebody who's very important to the meeting, let's say. And it's not uncommon that there would be such people. I mean, if you're an elderly person doing estate planning, then it's often very helpful to have somebody there who has information at their fingertips, who can make suggestions, and who can address what we've tagged as number 1 problem now about being able to be realistic and frank about who should do what and about the dynamics of your family. So if you're bringing somebody into the room that can play that role without inhibiting the candor of your conversation, without impairing the information that's available to the lawyer to be able to help you, then that's a good thing. But if they are going to have any of those adverse effects, then you need to not bring them. I'm concerned actually that some lawyers don't do this. Even though what I'm telling you is textbook proper, that a lawyer wouldn't bring anybody into that meeting that he or she didn't regard as essential. There are a lot of lawyers who just will not, dot that I or cross that T. And sometimes it's not a problem. If it turns out there is no litigation down the road about whether your will's being challenged and somebody is saying that this relative had a disproportionate role and they want to find out what was said in that meeting, they think somebody's unhappy with your estate planning, for example, and they've brought a lawsuit. You're probably gone at this point, or you may be incompetent, but they've brought a lawsuit, and one thing that they want to prove is that there was undue influence or fraud. In that case, then they're going to want to put somebody on the stand who can talk about what was said and who had what role. Well, normally they would hit a brick wall if they had called your attorney to testify, even after your death, believe it or not. Your attorney to testify, or of course anybody else that might have been in that room, because that is still protected information if they were essential. If they were just somebody who was riding along, your neighbor, and they were sitting in there and there's no argument that your lawyer at that time defending your estate can make to say they needed to be there, then that's a problem. That's a problem. But again, an entirely separate one and just as big an issue is having people in the room that somehow reduces or diminishes the candor that happens in that room. I can't say that enough. You've got to be under circumstances where people will, you especially, but people who are necessary parties that are in that room, you feel that you can speak frankly to the lawyer. For you to conceal that, a child has a problem of some sort, whether it's whatever it may be. It could be a criminal problem. It could be a psychiatric problem, whatever it is. I mean, your lawyer needs to know that to be able to make suggestions to you and recommendations. Not to mention for that to be considered in what the plan is itself as to who is a trustee, et cetera. So we'll come to this. So that's controlling who is in the room. That I could talk more about that. We've talked a little bit about it in the past. We'll come back to it, I'm sure. All right. Going to what I've listed as item number 3, choosing the right trustees. This kind of ties in with what we were just talking about. The trustee role is a difficult role. Now, if you simply have a will and you don't create a trust during your lifetime, it's called a living trust, or you don't have a trust created in your will, that's called a testamentary trust. If you don't do either of those things, then you don't have a trustee. But I'm going to assume that you know this much about your estate planning. As a matter of fact, I was so confident of this issue that I didn't list it as one of the top 10 mistakes. But I could have. Perhaps it would have pushed something else out of the top 10. But that's people who don't do trust. But I'm not going to do that show. So I'm assuming you have a trust. Either it's a living trust or it's a testamentary trust. So when you have that, you've got to have a trustee. You've got to have somebody whose job it is to run the trust. That's not an easy job. And even if you don't have a lot of assets, if you have $500,000 in assets, which is significant, or less, I mean, there's a lot of responsibility. The person has a duty a very, very high duty. It's called a fiduciary duty, the most solemn responsibility that the law recognizes. So they have this fiduciary responsibility to manage these assets in a way to benefit the beneficiaries. And that means no self-dealing. In other words, they can't make any decisions that benefit them especially, or even also unless they can justify it that it benefits at least as much the others. So it's a real selfless role, and it's hard to do. And it may not be suitable to many people that you might otherwise be inclined to give it to. It may be that the person who is most devoted to you maybe even lived locally, while the logistics are great for that, somebody who lives locally, that's great to choose to at least prefer them, all things being equal, as the trustee. But still, it's not enough. So it might be that person is somebody who just is not as responsible. They're not going to be good at some record-keeping responsibilities that they'll have. They have to place the money, whatever its amount, whether it's $50,000 or $1 million. They've got to know where to place the money that is wise and proper. It doesn't mean they have to be a financial manager. As long as they have the good judgment to know that, for example, they need to hire somebody at a good brokerage firm or some other third-party financial planner who at low expenses will maximize the rate of return. So there is some judgment involved. There's judgment in choosing the right institution or the right resource, but also considering that resource in the context of how much are the expenses. I mean, if you end up, somebody who doesn't know any better might think it makes sense to pay, 5% or more for management fees for a relatively, small or large, that's too much. But the point is, not everybody can do this job. So honesty is important. Matter of fact, honesty is in my judgment, one of the two things that are most critical for this role. Honesty, and the other one is good judgment. Again, that's not saying they have an education in these fields, whether it relates to real estate management or it could be a business that is transitioning, a family business. So that's more challenging for a trustee. But again, it doesn't mean they have to do these things themselves. They can use third parties, but they have to be ever vigilant to be sure that they don't waste assets. They have to make good decisions. So I think that often people, when they choose a trustee, they think that they have to choose based on their children, and if they have 3 children, they'll tend to have 3 co-trustees. That's often not a good decision, as you might imagine. I mean, it sometimes assures conflict, but it might also assure incompetence. I mean, it can be a mess, and sometimes people just don't want to think about that, and they want to charge forward in the name of family harmony, which is a good priority to have, is to minimize conflict, but it'll be maybe at the expense of problems later. So it's something to think about. Again, don't understand me to say that this has to be a professional. It does not. But it does have to be somebody that is responsible. And I would throw in a trait I didn't mention, and that's diplomatic skills. I mean, it's wonderful to have somebody who can be the peacemaker and also have good judgment and also have great integrity. So you may be gifted with that among your children. If so, I would say choose that person, and at the risk of offending your other children, or if it's not a child, at the risk of offending your children. Because ultimately they are the beneficiaries, remember, of this good decision that you're making when you consider that. So choosing a trustee is something, don't do it casually. Don't regard it as something procedural that you just need to get done. It's a huge decision, and it could very well determine whether your trust is even in existence over the period that you hope it will be, but especially over whether there's litigation and conflict within the family over that trust. So next item, coordinate assets with beneficiaries. This is kind of an interesting idea. It relates more to compatibility, and that's that depending on what your portfolio is, it might make sense to simply allocate things as percentages. I have 3 kids. They each get 33 1/3%. I have maybe grandkids, so I'm going to set aside 10% for my grandkids. I'm going to set aside 10% for my church, and I'm going to distribute 80% in equal shares to my children. That's what you commonly see sometimes in estate planning, and it's often a mistake because depending on what the portfolio or what your estate is comprised of, it may be much better to make specific bequests. Specific bequests mean that you look at the asset, you look at the needs of that particular beneficiary, and you say, is this the right thing to go to that person? For example, this is an easy example. You probably didn't need me to tell you this. Maybe you did. But if you have a family business, you need to think about, do you want to distribute it among your children when in fact there's one that has a real interest and one that doesn't so much? Now, the problem is paying off or treating fairly that other child. But often the right answer is not to simply give that other child equal ownership because it seemed like the right thing to do. It often sets the stage for conflicts down the road, which are the least of what you would have wanted. So you have to consider, are there alternative assets? Sometimes they're not. Sometimes 90% of someone's estate is a business, and maybe there's one child or maybe two children that are engaged in that business and a third child that's not so interested, if at all. So how do you write that sort of distribution? Well, it's not easy, I grant you, but you need to think about, if you're going to include that child as an owner, then you need to think about what the implications are. They can have non-voting stock. That's better than having internecine conflicts. Another way that's not uncommon is people through life insurance. They will create funds that are specifically for paying off somebody. So if there is a family business of any sort, then maybe a life insurance policy, depending on your age and your health, may or may not make sense. It is a common tool that's used. But there can be other ways. There can be a note where that third child receives a note in which is secured by the business, and they're to be paid out over a certain period of time at, say, 8 to 10% interest, a generous rate of interest. And that person should be delighted with that. They have no responsibility. They have no power or control, but that's the good thing. It's the power and control that this other child would have that could cause the business to fail or for there to be conflict. So one remedy to consider is the possibility of some sort of debt, which is paid over time. It could be 10 years, 15, 20. Sometimes if the business has the capability of getting a loan at your death, then that's another way to take care of that child. Or other family member, as the case may be. But there are different things. There's real estate. Sometimes it makes sense for everything to be sold and the money distributed equally. I realize that. But there are other times where maybe it's not a good idea to force a sale of the assets. And it may be that you need to think about compatibility first. And if there's a way to allocate those assets and satisfy the fairness requirements, then you can do that and keep assets in the family that really will provide much more benefit over time than perhaps selling them and just having money would. So think about that. Don't be shoved into a pigeonhole where perhaps a lawyer will say to you, what is the distribution do you want? You want equal shares. That's really the wrong conversation. Once, though, you've made it clear that you want to include all of your children, or as it may be, grandchildren, or whoever that circle might be, and it is important to know, approximate whether you want to treat them equally. But beyond that, it shouldn't be a conversation about just shares of your estate. It needs a conversation about the assets of your estate in many cases. Some of you, I understand, you'll sell everything and it'll be distributed. Failing to push the process along to its conclusion. I'm showing this as number 5. So this may seem like something that isn't as common as it is. Maybe it should be in a top 15 or a top 20 list or top 30 list. But I'm telling you, I shudder to think how many people go in to see a lawyer about estate planning. They'll pay something up front. They may pay half up front. Hopefully they don't pay all of it up front, because too often, lawyers are not incentivized to push it along themselves because they've gotten paid. This is a general comment about humanity, not just lawyers. So in this case, though, I think what happens is people make some sort of payment, not all of it, and then they get started, or worse, they don't make any payment. I should mention that. I think that's bad. I think if you go in and do estate planning and you make no payment, I would say that that's the largest percentage of cases where estate planning doesn't happen. It just doesn't get across the finish line, doesn't get signed off, documents are not prepared. Nobody knows at some point 10 years down the road, 5 years down the road, why it happened. The lawyers will say, oh, gee, we're waiting on you to do fill in the blank. You're saying, well, we're waiting on you to call us regarding fill in the blank. I mean, that's the way it happens, but I'm telling you, if I were to be asked to grab a percentage out of the air, I would probably say over a third of the people who go in to do estate planning, I mean, they've made the decision while they're there or before they got there, and they may even have paid something on the front end. I would estimate that a third of all the clients never complete it. And some of that fault is the lawyers, I know, but a lot of it is the clients. It's that life goes on, it gets in the way, you're busy doing the things you do every day, and who wants to think about death anyway? And besides, surely it's not going to come for a long time. Usually you're right, but a long time can be 5 years. It can be 10 years. So I listed this because it takes determination to get it done, and you can't count on your lawyers. I think that that's probably what happens, is I think that people come in, and in fairness, they're entitled to this expectation, really. You should. Anytime you're having services from a professional or services anywhere, the business person, who you've struck a deal with, you've reached an agreement, you've paid them some money, and they should be incentivized to push this along. It's the right thing to do, not to simply sit back and wait for you to come in and push it a step and then go back home, and you have to wonder for a while, wonder what's going on with my estate planning. You make an appointment, go back in, you push it a little further down the road or down the field, and then you leave and go back. So this process that's not the way it should be. A process like that, it definitely shouldn't be that way. So I'm not suggesting that this is just client's fault or just lawyer's fault. I'm just saying it happens. It happens, and it happens way too commonly. There's a chance I'm talking to somebody right now who paid something for estate planning that was some time ago, and maybe you didn't pay. It's most likely you didn't pay anything, but you told the lawyer you wanted it done. Lawyer said he'd do it. You left. Y'all exchanged a few letters, maybe even a second visit. As a matter of fact, there's a good chance there was a second visit, and then just attentions wandered and time passed, and so you're watching this video thinking, I need to get some estate planning done. So that's the reason that is on this list. So choosing the right trustees, failing to push a plan along, I could talk for an hour about getting this whole process done. Let me also include, before I leave that item, which is number 5, it can include where you actually go in and do sign, like you'll sign a will, you'll sign a power of attorney, perhaps durable power of attorney. So you'll get something signed, but then your lawyer will say to you, look, you need to change the signatures on certain documents to be sure that this is all in place. And this will tie in with another item I have on the list, but I can't resist going ahead and covering it now, is that often people will not make changes, or they will not complete a process that requires them to go to a variety of third parties. It's a lot of work. It's a hassle. And again, it's on a subject that nobody wants to fool with. It's a bizarre thing. Estate planning, everybody agrees, it has great gravity. I mean, it's huge. It represents the accumulation of your lifetime, whatever that is, and its transmission to those you love most and you hope will benefit in the best way possible, rich or poor. Those are your hopes for what you've accumulated in this world. So you'd think that estate planning would be something for which there would be a lot of motivation to go in and get it done. But we both know that that's simply not true, and it takes a Herculean effort sometimes to get family members to go in and do that. I mean, on the part, their loved ones will be encouraging their family members, and not out of selfishness, sometimes out of a little bit of self-concern, but more often because they know it's important to their mom or dad, and they're wanting them to get it done. But it's often not enough to sign those documents that you had in front of you when you were in your lawyer's office. That doesn't complete it. You may feel like it's completed. As a matter of fact, your lawyer may have failed to make clear to you that, look, we don't have this across the goal line yet. I mean, we're at the 99th yard line, but here's what you need to do for this to really achieve its purpose. So let's assume that there's a living trust attached. So if there's a trust as part of your estate planning, as there should be, then it's not enough for you to sign the trust. You have to think about putting assets in the trust. So we call it funding the trust. All that means is that you have this beautiful machine that you've designed and built, this container. It's a better way to think of it, this beautiful container, and now you need to put stuff in it in order to feel the power of it and to get the benefits. So the way you do that is some things you'll put in immediately. As soon as you sign and create the trust, within days or a week, you'll create a deed, for example, that might put certain pieces of real estate in the trust. You may change the signature card or the title on assets that you have with financial institutions. So those can be traded, whether it's banks or whether it's brokerages, whatever it may be. You can simply change on the account the name, and you've done a transfer of that asset to the trust, and the trust owns it now. Very easy to do. They'll probably ask for the front and last page. Sometimes they'll ask for a little more, but it's effort. It's effort. It's not hard. It's just effort to do it. It's not something most people want to fool with. So I think for all those reasons, often this just doesn't get done. Now, there will be some assets, though, that you won't put into the trust immediately, like a retirement plan, your 401k, for example, or your IRAs. Those you'll want to change the name on the card. So you have your ownership documents, which is really just an account name. So you go to a financial institution that's holding your IRA funds. You say, I want to change the name from Joe Smith to the living trust of Joe Smith, or whatever you call your trust. You can call it anything you want. Doesn't have to have your name in it, but it's your trust. So they'll very simply make those changes for you once you provide them evidence of the trust, et cetera. But in this case, though, what you've done is you've done one of two things. You've either put it into the trust or you've changed the beneficiary clause on that document. You also have, with virtually any financial asset, whether it's an IRA, 401k, bank account, regular brokerage account, whatever, you always have your name on the account, which shows the ownership, and then you also will have a designation for a beneficiary clause. So this is a transfer on death, payable on death. Most it's called today payable on death. Transfer on death. So in some cases, you will change the title. But in other cases, like with IRAs and 401ks, you're going to keep the title the same. What you're going to change is the beneficiary clause, because you don't want to trigger tax consequences right now while you're alive by moving that into your trust, which it will generally do for almost virtually any of these ERISA accounts. So instead, what you want to do is simply say, when I pass away, this is to go directly into my trust. And the magic of that is wondrous, meaning it bypasses all that stuff associated with probate, which I've talked about at length here, and I don't want to subject those of you who've watched this show for some time to the same sort of points I've made before, but I don't want to fail to mention this because I know there are people who haven't watched this before, and you can avoid the entire process of probate, all those things associated with it, the higher probability of litigation, everything else that goes with it. Money which you pay for all the costs coming out of your pocket, your estate. So you can bypass that and put it in a trust. So completing, though, those documents related to your trust, part of your estate planning, going around to these different institutions and taking care of those things according to whether you want it to be in there immediately or do you want it to go in at your death. Many things will go in at your death, and that's just as good, just as valid. It happens instantaneously when you pass. No probate. Doesn't go through probate at all, so it's really available for distribution, almost conceptually an hour after you passed away, if your family were if you were so loved by your family that they were inclined to distribute your assets that soon. My point is that's what you want to happen. You want the assets to go where they need to be with as little cost and delay to your family as possible, to those you love. So I think a lot of this just doesn't get done. And the other piece of that about having estate planning done is that it's not just completing that first round, which may be the final round, incidentally, if there aren't any significant changes. But I can't resist throwing into this what I'd listed as a separate item on this list, and that's the need to update based on changes. If you acquire certain assets, you need to change the beneficiary clause in those assets, or you need to record the title of the trust if you're going to put it in the trust. This sounds like a lot of work. I'm telling you, it's not a lot of work. It's very easy to do. Some lawyers have clerks that'll do this for you. They'll charge you something, but they'll do it for you. Another thing that often happens, though, is beneficiaries. Somebody will pass away. Maybe there will be a change in attitudes or relationships or something, and you want to amend that. Well, don't do a planning and then don't think about it, and then assuming you pass 15 or 20 years later, there could have been changes that suddenly make that plan obsolete or a bad idea in whatever form that takes. So it's important to circle back and look at it every now and then. Some lawyers suggest once annually. That's pretty vigilant. I wouldn't insist on that. If it were me or my family, I think that as long as you're conscious of it and you do circle back on a regular basis, remember, your lawyer that's doing your estate planning, it shouldn't be simply a transaction. It should be a relationship. We've talked about this before, but it should be a relationship that exists over years. It's not that plan that you create and hopefully you execute properly or you complete properly all these steps I've described and get it done so you do get the ball across the goalpost. But that's for then and there. Now, there's a good chance, again, that you'll never have to change it. I don't want you to think that, gee, it sounds like this mammoth effort to get this thing done with all these steps, and finally I get it done, and now I may have to go back and do it again. You may have to change some things again, but those are easy. Changing a trustee, for example, if you conclude that someone's judgment is not what you would have liked, or you've lost confidence in their judgment, that's common. Is that somebody will change a trustee that they've set up. But there can be lots of things that happen over years. So there's some chance that you'll have to go in and sort of fine-tune or make some small adjustments to your plan. These are often not very expensive. Matter of fact, now everything is digital. Everything that we store in the cloud or in a database in-house, and so all those records are there, and it's so easy to make changes. Those days which I can remember when you had typewriters. You had typewriters in which you had people who would make a mistake and they have to tear it out. Then they had these mimeographs. Now, Justin, you've never heard of this, a mimeograph?
I know the name, but I couldn't tell you what it is.
Yeah, well, it makes copies through the benefit of this ink sheet that's behind it. And the world's changed. So the good news for you, client, prospective client, or estate planner, is that any change that you'll make, don't fear that you're going to spend another ton of money. You shouldn't. And if a lawyer suggests you are, then maybe you need to get a different lawyer. But that was item number 6. So let's go to 7. Proper disclosures with an explanation to appropriate family members. This is something that we have talked about before. It's something nobody wants to do, and I understand that, but studies have shown, this issue has actually been researched, and lawyers, just based on their experience, all agree that in some cases it makes a whole lot of sense to sit down and talk to your loved ones about what you're doing and why you're doing it. It's not always the right thing to do, but it's often the right thing to do. Whenever somebody feels that they were cheated because of another family member, a sibling or a cousin who was with you a lot, who had a chance to sort of poison your mind toward them, toward this person who was left out of the will. I mean, whenever these people who are excluded or treated disproportionately less in terms of assets, whenever they can easily imagine that there was chicanery going on, that there was something, manipulation, dishonesty, undue influence, then they will imagine it. And I think that this is less a product of pure greed than a product of someone being angry, feeling that someone had done them a great wrong and they were determined to right it, with a little bit of greed thrown in there. Meaning it's not often a selfless act, but I'll tell you, I don't think greed is the primary motivating force in litigation among families that had actual relationships at the death of a patriarch or a matriarch, whoever it might be. Now, when it's families that don't have relationships, then yeah, that's going to be more of a monetary dispute. But where you have families that have relationships, oddly enough, some of the stronger or tighter relationships, and somebody is surprised in a bad way when they hear what was in a will or in a trust, then that's an invitation to conflict. So I would think seriously about, if you're going to have any sort of disparate distribution, I would consider seriously the possibility of sitting down with your kids and having a conversation about why you're doing it. Maybe you just sit down with the one that you do expect to be unhappy with the outcome. Maybe that's the one you sit down with. There's no easy or reliable rule of thumb as to how and who to include in this, except to know that somebody who's going to get an unfavorable surprise, and that may include everybody, then you need to explain. You need to explain why. And if there's a second wife or a recent wife, whether she's second, third, or fourth, I would put a exclamation mark at the end of everything I've just said. When that person is included or even excluded, sometimes it's just an invitation to having a 10 or 15 or 20% of your estate eaten up in litigation to lawyers, and not to mention the years that pass. And I mean years. It's not unusual for these conflicts to go on never-endingly. So I won't dwell any further on that, but it ties in well with completing the process. If you think of that as maybe a stage, the final stage of completing the process, then that makes it more likely to get done. It should be on your list. Just like changing those titles of documents. You should put it on your list. Now, I know some people are tempted to think, look, I know this conversation is important, and I can tell you that I definitely intend to do it, but I'm going to wait until just before I die. Well, you see the problem with that plan. None of us knows. So it might be that someone had the full intention and no doubt would have had the conversation, except for a car accident that occurred, at a time 10 years before they thought that they'd be needing to have that conversation. So, all right, that was 7. What do we go down to? 8. Getting and securing signed copies of estate planning. This makes the list, although it would be toward the bottom, but it does happen. Maybe this would technically fall out of the top 10, but definitely be a top 20. Where you have somebody who has passed away. Now there's this argument about where the will is. The will is, a copy surely is going to be with the law firm that prepared it. However, if that lawyer now is retired and they have closed the office, they probably got rid of all their files. I think the rules of ethics require they keep their files for 5 years. But then they can't simply destroy them. They are required to send, the information they have for each former client, to send that information to the client. But as a practical matter, clients don't receive it because clients have moved. Lawyers sometimes just simply don't know where to find clients. So while you'd think that a rule like that you can destroy records after 5 years, you'd think that would be safe as long as the lawyer is required to send the full file to the former client. That sounds like a good policy, but I can just tell you it often doesn't doesn't do the trick. So you have somebody who they left their records, their documents, all their estate planning with their law firm thinking that's who I'll use. It'd be different if law firms who do estate planning were typically, a mega firm that has offices in 30 cities or say 10 cities. And in other words, an ongoing entity, an entity that is perpetual, so to speak, until they go bankrupt. But that usually doesn't happen to law firms. So if it's like most estate planning firms, the vast majority of estate planning firms are small firms. So you want to think, and I understand that, but sometimes they're a single lawyer. And if you're relying on a single lawyer to be there, that's a pretty thin reed. It is reasonable to expect a lawyer, your law firm, to be there, but if they have 5 or 6 lawyers and they're an actual law firm as opposed to Bill Smith's law office, then yeah, that's a pretty reliable bet. But anyway, whether it's because that the law firm the person had retired or whatever the reason, it's not uncommon for documents to disappear. So you should have a signed copy of your documents, and a good place to put it. And there are different theories as to the ideal place. I think the best place to put it is in a lockbox. Lockboxes are made available by banks. They follow the deaths and the records that are disclosed in the obituaries, and they know that they have to notify people about these boxes. So banks and trust companies are generally on top of this, and you can count on anything that's in your name being discovered through the lockboxes. But sometimes sometimes people will keep things at home in a vault or even in a drawer, but a place where it's safe and they have confidence that the person who needs to find that and implement it, the trustee or the personal representative, if we're talking about a will, and it could be the same person, but that person needs to know where it is. And that won't be the only copy, of course, because there will be, the copy at your law office. But I can just tell you, people move around. They forget where they put it. Sometimes people who do estate planning, in fairness, they're old enough to where maybe they're vulnerable to forgetting where they had it. And it can be a mess where you've spent the money to have it prepared and no one has it after you've passed. And sometimes even a will that and there's litigation to this effect, case law that you study in this field as a lawyer in estate planning. There are cases where people know a will existed, and that's not unusual. They'll know that there was a will. They'll even maybe know what lawyer the person had used years ago, but that lawyer doesn't have it or can't be found. And the argument is made that you destroyed the will, which is a way of revoking a will. One way to revoke a will is to void it and write across it that you're revoking it. Another is to create a new will, and by definition a new will, but it's better to say in the new will that you're revoking the previous one, but a new will would revoke the previous one to the extent it's inconsistent. And then another way that you revoke a will is through destroying it. And so it's argued that maybe you decided to rescind all those provisions that were in your will. In this case, we'll assume people knew generally what you intended to do. That's not unusual. But suddenly the will's gone. Guess what decides now what happens to it if it was a revocation? If they believe that the lost will or that the will was not lost, but instead was revoked by destruction, and that's often the argument of the person who wants instead the distribution to be what would be intestate succession laws in Missouri or whatever state. The intestate succession laws are the laws that kick in when you have nothing, when you don't have a document, you don't have a will, you don't have a trust. And if that kicks in, they might be much better off. So here you end up, because they can't find the document, you end up in litigation. And this litigation can be ugly. You have one side arguing, no, it's lost, and we know what it is, or we have a subsequent copy. Sometimes that'll happen. Somebody will come up with a copy, which, because there's so many strict rules about how you execute a will, often those are flawed. And if it's a flawed will, then it's not going to be honored by the court. So technically, if you had a will in which people could prove that the will existed and what was in it, if that were possible to prove that and that you executed it correctly, the law, let's say they found the lawyer and the lawyer said, I don't have a copy, but I know it was done correctly. I know that we executed and I can tell you what it said. If a court believed that evidence, you could technically have a will enforced without the copy. So because the idea is it was a lost will, but they can establish what were the contents of the will, and the will was executed correctly. So that's the argument that those who want to uphold the contents of the will want to make, and then those who oppose it say, no, the fact that we don't have a copy of it means it was destroyed, consciously destroyed. So that means that it's thrown out entirely, and we have the laws of intestate succession that will determine, and that means I get an equal share. That person who's a proponent of that view. So anyway, such is the nature of estate litigation. I mean, it's ugly, probate litigation by its nature. What do I want to get to here? Getting and securing signed copies of the estate planning we just did. Building plans based on immediate distribution to your loved ones. This is a huge one. Definitely should be in the top 10. And that's the fact that many people don't realize that they don't have to simply hand their stuff out the moment they die to their loved ones. But they think that that's the right thing to do. Often lawyers do not explain to them adequately, in my opinion, that might not be a good idea and that it's very easy to do this differently. And most importantly, what the advantages are of doing it differently. So I like to make sure that people who are doing estate planning, that they understand that simply handing stuff out, as I would bet 60, 70, 80% of wills do that. Even trusts will do that, where after you die, they've avoided probate, and then they just have the trustee's job is to hand out the stuff. And many people think, well, my children, though, they don't have a handicap. They're not minor children. There's no reason for me to not just give my assets to them. But I mean, there are reasons. There are wonderful reasons. And we don't have to assume that you have millions of dollars. But to be able to have a trust in place that will give your child complete protection from creditors, that will give your children, your adult children who are, let's assume they're healthy, self-sufficient, even, living professional lives. Let's assume they're doctors and lawyers. The point is, it's better for you to keep it in the trust for their benefit because they can't do it themselves. They can't give themselves that sort of protection, that force field that you can give them. And what that does is it means that if they make a mistake, have a car accident, the stuff in the trust can't be touched if you create what's called spendthrift provisions. And what if they get a divorce? Guess what? Those assets that you gave them 2 years ago that probably ended up in their joint account means it was converted to a joint asset, a marital asset, and as a result is subject to distribution in a divorce. To the extent that you can protect your children from the ever-present risk, in my judgment, of divorce, at least if they're married, and not to mention creditor risks, not to mention bankruptcy is a risk. Bankruptcy is a little different. I mean, it's not just somebody who decides to sue you in a car accident, which we know we live with a lot of lawsuits. We're in a litigious society, but sometimes your child could be a professional and have a business, and the business fails. So bankruptcy happens to good business people, believe it or not, and to think that you have assets that are protected, and furthermore. And this is what isn't emphasized enough. If you leave, say, a couple $100,000 to each of your children, Scout, wait, my dog's getting impatient. If you leave $200,000 to each of your children, we'll just use this as an example. Could be less, could be more. There's a good chance that they won't instruct or ask their trustee to distribute it to them. remember, I'm imagining that if your children are healthy, now remember, if they're not healthy or if they don't have good judgment, we have rules for that too. So my arguments are even more emphatic if we're talking about that. But I'm assuming that the best case you could make for your thinking, I should just go ahead and give it to them. They're good kids. Why not let them have it now? Well, you can do all of that, meaning you can put provisions in the trust that will give the trustee discretion to give them money, not necessarily any time they want it. You could say that, but more likely you would say, using the trustee's discretion. So your trustee, remember, somebody you've chosen for their good judgment, for their discretion. And so that person would be pretty liberal in giving your children access. So this this hypothetical doctor or lawyer's son, if there's $200,000, they're probably earning decent money. They may want to reach in and get some of that. They may say to the trustee, well, give me $50,000 for this. And the trustee will probably do that unless you want it a little tighter requirements. You control that. You control the spigot. So I'm just telling you what I've seen is that these hypothetical scenarios where you have somebody who is self-sufficient already, a doctor or a lawyer, for example, they will often choose to leave it alone and let it go to the next generation with all the benefits they had. So in other words, you tee it up not only for your children, you tee it up for the next generation. And the next. I don't know how much money you have or what sort of inflation or rate of return you'll earn on the money that's invested. But my point is you can create what's called a dynasty trust, but it doesn't mean you have to be rich. It does assume you have a little bit of money, but not rich. And then your children may choose to draw it all out in short order. That's fine if you want to permit that. But the point is you can tee it up for them to be able to have generational benefits. So this is much better plan than having a plan where they have to accept the check when you pass away. They don't have control. If you just put distribution because your kids are adults, that let's just give them each. I have 3 kids, give them each a third. I'm telling you, that's not the best thing you can do for them. But once you say that, they don't have a choice anymore. Even if they wanted what I'm describing, which they should, they don't have the power to do that. That check's going to be written. That's theirs now. So they can't create the trust I'm talking to you about for themselves. They can create it for their kids, but they can't create it for themselves and their life. And all those protections I was telling you about, they can't do that for themselves in most states. And even in the states they can, it's much more restrictive, lots of tough rules when you try to create that for yourself. So I identified that because I kind of like to give that speech because I'm a big believer in it. As those of you who've watched this before know, I do this with my kids. That's exactly what I'm going to do with my kids and have done, in fact. It's the plan that's in place. So I'm thinking that we'll break off here and we'll make this 2 shows, and I'll pick up on a second show in which we'll talk about the next, what do we have left? 4? Yeah, we have 4 items that we'll talk about in our next show. So I hope this has been useful to you. My goal in doing this show is to be helpful, is to allow you to make better decisions as a client of a good estate planning attorney. Naturally, we're fans of Tucker Allen, so we'd love for you to consider Tucker Allen. But the point is, I want to equip you to be a great client and get the results you want. So that concludes this episode. Talk to you next time.
You've been listening to Life's Third Act, a podcast for thriving in retirement, sponsored by Tucker Allen, your estate and elder law advisors. Each week, we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.